My apologies about my delay, folks. Court does call the case of Gil Sanford versus Susie Norman. Your name, sir?
Gil Stanford.
Either place is fine. And your name, ma'am?
Susie Norman.
Okay. I had you two here before a long time ago.
Yeah.
7 times.
Thank you for counting.
Good morning, Judge.
Good morning. And then there was a general civil case which was filed, and that now has been assigned to me. Judge Barr had it for the purposes of judicial efficiency. So that's where we are. Where are we with these cases? Anybody can go ahead. Go ahead, sir.
I have filed a request for 12th entry on it, and she has asked to open up a previous case that I filed an objection to.
You objected to the opening of the 2024 case, right?
Pardon me?
You objected to the opening
Of her.
of the 2024 case.
Yeah.
Okay. All right. So I'm just trying to get my files right here. I think your claim, sir, which is in the case. Oh, maybe I gotta.
You want me to give you a quick overview?
No, I'm just making sure I have the right files. I may need it in a second, but when I looked at this before, because now I have an extra file, which was the one she wanted reopened. Okay. Ms. Norman, what's going on from your position in this?
Well, it was my understanding that in October of 2024, the case was finished. Like I said, there were 7 cases, or excuse me, 7 times we came in front of you. I had a case against him. I dismissed it for the possession. It was a possession case. I had a case that showed that he had no certificate of occupancy. The house was not habitable, per the township rules. And just to get some peace and to keep, out of court one more time, we dismissed my case and I thought it was over. I had money in escrow, we split that. So I thought it was over. And now here we are again. And I did send a motion to reopen my case, if this is going to go further, so that everything kind of gets heard and finalized.
Let me ask this, sir. Well, right now I have a October 22nd, 2024, but I think that case was dismissed. There was a conditional order of dismissal that was to follow in the 2024 case. So what is your claim, sir?
My claim is for physical damages that her and her family caused to the property and lost rent.
Well, what happened in the once she left, what happened to the security deposit?
Are you asking me?
Yeah,
She did not have enough money, paid into, to fund a security deposit. She did not have that initially, when she first moved in. And she was trying to get caught up on that, but she never had enough money, to fully fund a security deposit. I sent her a letter after she moved out listing images, that, basically, she did not object to that. That was the damages, it was about $7,000, physical damages to the house.
but
But there was not a security deposit, being held.
okay, well, here's the other issue. Was there, as I'm recalling in the case, and it's all kind of coming back based upon some of the things you're saying, the house did not have a COO.
At the time, or during the course of her tenancy, I was not aware that it had expired, and you're correct, there is not that COO. After she moved out, I made the corrections, and I have a new COO, and I think.
But during the time that she was renting, you didn't have one.
That's correct.
So you're first of all claiming, I understand that you have damages and you said rent. But
and the rent,
how much are you claiming in rent?
the rent, and the rent that I'm claiming is all after the COO.
How much are you claiming in rent? After the yeah, but go ahead.
I don't need that. Let's see. Well, my total, on my initial, complaint and amended complaint was 29,179. And prior to that, it was, the damages were, 7,000 something. So whatever the difference is there. I have to do some math here to get an exact number on that.
Okay, you told me at the beginning you're claiming damages and rent.
Correct.
So of what you're claiming, how much rent are you claiming?
That total,
Let's try the other way. How much damages are you claiming?
the damages were, I thought I had that separated under here. First a minute, like, the damages or the, what I'm claiming for damages was $7,138.17.
7,000 what?
7,138.17.
And those are all damages that you say are relating to her occupancy of the premises.
That's correct.
Okay, and what? And the rest is rent?
And so, so it is, $22,041.36 is the total complaint. So if we subtract 7,000 from that, is whatever that comes to.
So, sir, how are you? Let me just ask you this. If, and this is in regard to the rent claims, if at the time she occupied the premises, you don't have a COO, and as such can't charge rent, theoretically, how do you then at some point begin charging her rent after she's left?
Because we had a lease that went through,
But the
August.
lease is going to be void, sir, because you don't have a COO. You can't enter into a lease legally.
Well, that was a contract that we agreed to, and,
Okay, you can agree to whatever you want to, but you're asking this court to basically enforce what may be an illegal lease.
I made it legal when I got the COO.
But she had already left.
She vacated, at that point in time after, we had our other case.
Okay. But
And I corrected the, oversight that I did not have COO.
but she's no longer there.
No, she's not.
So maybe follow this. If you're not permitted legally to enter into a lease, but you sign a lease, the question for the court is whether or not that lease is void, because you can't legally do that. But what you're then attempting to do is take part of that after you've had an agreement regarding her leaving the premises. She leaves the premises, you then make your corrections, get your CEO, and now want to charge rent on a lease that was probably void from the beginning.
I guess the question is,
No, I like my question better. And that
Well-
is, how do you do that?
well,
Yeah.
was the, I'd have to look at the law. Does the law say I can't charge, or without the COO, I can't charge rent, or I
You
can't?
can't rent.
Pardon me?
Theoretically, you can't rent. You can't rent the premises.
I understand what you're saying, yeah.
Which means, since you can't rent it, then my question to you would be, if that's the case, how can you sign a contract to rent the premises?
Well, we did that. She moved in and she damaged the property, so.
I'm just talking about the rental portion right now.
I understand what you're saying.
But then it gets even, because in the 2024 case, which I understand why she wants to reopen, the claims were basically dismissed, rent waived. There was then a split of the escrow between the two of you. So at that point, the relationship from a tenancy standpoint ended.
But what was agreed to in the dismissal of that, there's a statement in that line number 6 that says the defendant may be liable for money damage for additional rent or damages to the property.
Okay. I'm not dealing with the damages right now.
Right.
I'm dealing just with the rent. If you couldn't charge rent from the beginning, how can you then decide to charge rent?
I see what you're saying. I understand your legal argument there, and
I don't make legal arguments.
well,
I make rulings
all right.
that everybody says.
So I see what you're saying. So maybe that's the case. I cannot charge the rent that I'm asking for in this.
Okay, that got you there. So now your claim is 22,000?
No, the damages are 7,138.17.
So now that's what the fight is about.
That's correct.
Okay. So when she moved in, let's just try to get some things clarified. When she moved in, was there a rental check-in list?
There was,
Was there?
yes.
Do you have a copy of it?
I don't know that I do have that with me today. That's in my other file from the previous case. But there is a check-in inventory list on that.
Pardon?
There is that inventory condition.
Okay, so you have the one that she filled out?
I don't believe she ever filled one out.
So where is this one coming from?
Where is, I have one that I filled out when she moved in. I have another one filled out when she moved out. I do not have that with me today.
You have one that, say that again?
Pardon me?
Say that again to me?
I have one that I filled out when she moved in. I have another one I filled out when she moved out. I gave her a copy of that original blank form. She never filled that out and sent that to me.
So there isn't an inventory checklist.
There isn't one?
So there really isn't one.
Yes, I have my copies of that document.
Okay. Prior to renting to her, did you rent to somebody else?
It had been rented previously, yeah.
Do you have their inventory checkout from the previous tenant?
I do have that also.
Okay. Did you send her a list of the damages you're claiming?
I did.
All right, Miss Norman, what's your response to the damages?
Well, first of all, I did fill out the inventory checklist, myself and my daughters, and I did submit that to him. And what was the second? I'm still back on, I
Oh,
didn't.
it's okay. Did you get a list of the damages that he's claiming?
No, I did not. What I received was the filing from 6/3 for the damages. He never returned any of my security deposit, so he's incorrect. And in that file, and I hate to go back, but in that file, there are money orders, several of the payments that I made to him. So I did not receive an itemized list within 30 days. The first time I'm hearing
Did he have your forwarding address?
yes, he did. And so did Mr. McCurgy, who was an attorney for him at the time. So they both had it, and I did receive the 6/3 filing paperwork at that forwarding address. I
Got
did
it.
not receive anything else, but apparently he filed something in December that was just
Okay, so
dismissed.
ma'am, how much are you claiming You paid in a security deposit.
$3,500.
Sir,
Yes,
do you agree that she paid 3,500 in a security deposit?
I do not agree with that.
How much do you think she paid in a security deposit?
I'd have to review my records, but I think it was.
Hold on. When you sent out the sheet to her, you had to subtract out, you would claim
Oh, yeah.
damages, and then you had to subtract out what you had.
And I had no money in a security deposit because,
Well, hold on a moment. You just told me a little while ago that you did because she didn't pay it all.
when she moved in, she did not have enough money, all of the cash that I required for her to move in. She was short, the money that would be for the security deposit. She said she was gonna pay that and get caught up on that. Hindsight is always 20/20, but she never got caught up on that. So she was all.
So she's saying she paid 3,500. You're saying she didn't pay any.
She did not pay 3,500.
Different answer. She's saying she paid 3,500. You're saying for a security deposit. You're saying she paid nothing for a security deposit.
My recollection is that she did not. Again, I'd have to look at my notes and my numbers that when she moved in, the exact number that she paid.
Okay, sir, hold on, because you told me two different things here today, at least. As we sit here right now, can you tell me whether she paid a security deposit?
I don't believe she paid a security deposit. I don't believe she paid enough money at move-in to cover.
How do we not know that?
What's that?
How do we not know that? We being figuratively, how do you not know that?
Well, because this whole episode of her tenancy was a constant battle trying to help her get caught up. I had offered her a couple different options for payment plan on that, and she kept shifting gears and paying me oddball most of the money. It was the accounting was rather convoluted.
In your lease that may be void, does it say she paid a security deposit?
The lease calls for, I believe it was 3,500.
Didn't ask that. Does the lease say she paid a security deposit? The lease should indicate that she paid a certain amount for a security deposit. It should also then indicate that you are then holding that basically in trust, and it should then list out the financial institution at which you are holding that security deposit.
That's what the lease states, that the security deposit amount was, and again, I think it's at 3,500. I don't have that lease with me. That's in my file for the other case. You know, wasn't ready to tackle this part of it.
I don't know what that means. So you would agree, at least as we sit here right now, that the $3,500, the lease indicates she paid it and that you're holding it at a particular location.
No, I would say the lease calls for that dollar amount, but she never paid it. I gave her a receipt for the money that she did pay, but she did not pay all the money that was due at time of movement. And I can, we'll have another preliminary examination. I can bring all that documentation in, including the.
I would give anything to be in a preliminary examination right now, but no. All right. So Norman, anything else you want to say?
All of the receipts that I paid are in the file. That in the case that I'm asking the court to reopen, I was paying Mr. Stanford $2,126 every 2 weeks. He
How
is
much
in
was how much was your monthly rent?
$3,300. And to get caught up on the what he was saying, I'm behind. I was paying him $2,126 every 2 weeks, and those money orders are in that file. The court
And
has
so
them.
you're saying by doing that and paying this excess amount, you paid the security deposit.
That is correct. And I upon move-in, actually, I was on a travel assignment. I'm a travel nurse. I was on a travel assignment, and I sent him $4,000 to hold it. So that was over the $3,300 first month's rent. And then when I got there, I paid him $1,750. So all of that information, the court
So you
has.
gave him $5,700 at
Okay.
move-in?
I believe it was $5,750.
Okay. Sorry, didn't mean to leave out the 50.
Oh, no.
So no, it's okay. So you paid 50, you recall that, sir?
She did make a large payment.
Okay, not what I'm asking. Do you recall her giving you $5,700?
The exact dollar amount, I'd have to check my records. But yes,
Okay.
she paid,
A sizable amount.
a sizable amount, yes.
So if she paid the 57 and rent was 3,500, 3,300 a month, what did that difference represent?
My throat is still dry here. My lease calls for certain things that if she pays money, that money is allocated to.
Okay, here's what I'm gonna want. No, we're gonna stop today because everybody else in here probably wants dinner and we're never gonna get there. All right, so I'm gonna adjourn this out. Ms. Norman, I want to make sure do you have a list of damages he's claiming now?
I do not.
All right. You are to supply to Ms. Norman a list of the damages you're claiming. Understood?
Understood.
I also then want an accounting from the landlord of all monies paid by Ms. Norman.
Okay.
I then want, and again, this has to come from the landlord, I want the previous tenant's inventory checklist as well as the previous tenant's inventory checkout list and the initial and concluding inventory checkouts for Ms. Norman.
Okay.
Understood?
Yes. I believe, and I can't. Yeah. I did an extensive amount of work to that property just before she moved in. And I can document I give you, show the work orders of all the things that we did on that property before she moved in. But I can give you those things and I'm gonna include that.
Why are you telling me that?
Well, because the
previous tenant's inventory checkout list doesn't look good.
well, the house had been rented through Washtenaw County as a halfway house for Michigan Department of Corrections people to be basically coming out of prison. That had been rented that way for several years. There were some rough conditions of it, and we went through and replaced a whole bunch of things. Did a major, you know.
But that would be, I guess I hear what you're saying, but that would be based, that should be clarified on the move-in checklist.
Yes, it is.
Okay.
I mean, from this, Norman, right?
Yes.
And it is very clearly stated in that.
But you're saying she didn't fill it out. You're saying you filled it out. But she's saying she did fill one out.
Maybe she did. I have to check my record.
So you don't know?
Not off the top of my head. I don't think she did.
All right, you just told me that she. Okay, all right, fine. I just want both of them, the previous tenant and hers.
That's
All right, so everybody got what they need to bring me, and I need it sent to the court. How long is it gonna take you to pull all that together, sir? Because that's really,
3-4 weeks,
wow, okay.
whatever.
No, that's fine.
I will put together photographs and whatnot of all the things, including condition, so you can see all the information. I'll send a copy.
Well, I get that, and you can include them if you want, but right now I got to figure out what the heck we're fighting about,
Okay.
or you guys are fighting about. We're not fighting anything. Oh. And what's the one after that? Got it. Okay, so if it takes you 3 or 4 weeks to get that done, and then that's gonna put me mid-December, Ms. Norman would have to look at it and respond if she deems it appropriate. So what I will do then is I'm adjourning these matters to January 6th, 2026, 9 a.m.
And cancel the non-jury trial on December 16th.
Oh, yeah, that's canceled.
I assume.
Yeah, that's
So January 6th.
that is so canceled.
And at what time?
That'd be at 9 a.m. because we got to figure out what we're fighting about.
Yeah.
Okay.
That-
What date are you going to get these to the court?
Month from now.
All right. And today's the 18th, right? All right. You get those to the court by December 19th. All right. Anything further from either side?
Judge Simpson, will you rule on the motion to reopen my case? Part of the reason why this journey started was because the house was inhabitable and I called the township for an inspection. So all of,
Go ahead.
I see your hand go up, so I stopped.
Yeah, I
talking.
know. That usually means be quiet, but I realize you're on Zoom. But go ahead. I'm listening.
Okay, so that is all of that information and damages and mold and all of the things. I have photographs in that file.
I know.
So
You know, as you guys were talking, it's kind of like having a bad dream. It all was coming back to me.
yeah,
So I remember the whole thing, kind of.
yeah, I figured that you.
And so I know that exists. I don't know for the purposes for which you want to use it for that I need to necessarily reopen the case. Because I realize there is evidence in that case that you may want to use. And I don't have a problem with that. I don't really want to reopen it because there was an agreement between the parties that goodness knows I don't want unraveled because that becomes my start.
Yeah. And I get that.
So at this point, I am going to deny your request to reopen without prejudice, meaning at some point, either the court or you can raise that again, and I may reopen it if that becomes an issue. Okay?
Yeah. Just one other question.
Sure.
So as far as the deposit goes and within the 30 days and me not receiving that, wasn't he past his time limit?
Okay, I can't answer that
Oh, okay.
because I'm not clear on any time limit because you have to understand that I can't begin to even go through that analysis when you're telling me you paid a security deposit and he's telling me you didn't pay any.
Okay.
So I have to first figure out whether or not there's a security deposit and then what that is subject to, and then whether or not the other parts of the statute have been followed.
Okay.
Make sense?
It does.
I know. Everything I say makes sense. Thank you for saying so. All right.
Welcome.
All right. Okay, folks.
See you in January.
We'll see you in January. Have a great
Okay.
Thanksgiving. Happy holidays. Take care.
Thank you. Take care.
Yeah, all righty.